Hi, I'm Martha Warriner, a California bankruptcy lawyer with over 40 years of experience. Welcome to my YouTube channel, Bankruptcy Basics. Today I'm going to answer some of the most frequently asked questions about bankruptcy. This is installment 2 of our FAQ series. If you missed installment 1 or want to check out installment 3, you'll find those links below in the description. Let's dive right into your questions. The first question I get all the time is, can I protect my assets? Here's the good news. If you're a typical debtor, your assets are probably all exempt. There are two sets of exemptions that allow you to protect your assets: a federal set and a state set. Most debtors who file Chapter 7 can use these exemptions to protect all of their assets. But here's the thing. These exemptions vary widely from state to state. So to determine what exemptions are available to you specifically, you should consult a local bankruptcy attorney. Most of us offer free consultation, so there's really no reason not to get some professional guidance. Question number 2, should I reaffirm my car loan? Probably not. If your car is worth less than what you owe on it, you should almost never affirm your car loan. Why? Because it means that no matter what happens to the car or to your life, you will owe the full amount of the loan. The only exception to that rule is if the creditor is offering to substantially lower your interest rate. Now, if you live in California, you never need to reaffirm the loan. Just keep your payments current. Many other states offer similar protections, so definitely check with a local bankruptcy attorney. Here's something else to know. Reaffirmation agreements have to be approved by the bankruptcy court, and many judges will not approve them unless you get something in return, like a lower interest rate or lower payment, or you can clearly afford to continue making payments no matter what happens. Question 3, can I keep my home? If you own a home, you are entitled to exempt your equity up to the prescribed amount under either federal or state law. However, if you want to keep your home and you have a mortgage, you will need to keep making payments. If you're behind on your payments, you'll probably want to file Chapter 13 so that you can make up the back payments over the course of your Chapter 13 plan. Now, if your equity exceeds the amount of your homestead exemption, the trustee can sell your house unless you're able to negotiate a payment plan with the trustee. If the trustee does sell your house, you'll get to keep the amount of your homestead exemption out of the net sale proceeds. That's after the mortgage and costs of sale are paid. If this sounds complicated, it is. You should probably consult a local bankruptcy attorney to advise you if you're in this situation. Question 4, can bankruptcy stop a foreclosure? Yes, for a time. Once you file a bankruptcy petition, an automatic stay goes into effect that stops a pending foreclosure from continuing. But here's what happens next. In order to proceed with the foreclosure, your lender will have to file a motion for relief from the automatic stay, asking the court to lift the stay so the foreclosure can continue. The court will consider a number of factors in making this decision. The most important factor is whether you have any equity in the property. If you don't have equity, the court will likely allow the foreclosure to continue. The most important factor is whether you have equity in the property. If you don't have equity, the court will likely allow the foreclosure to continue. If you do have equity, but you're behind on your payments, a Chapter 7 will not give you time to make up the payments and reinstate the loan. If you're behind, you'll likely need to file a Chapter 13 unless you are able to negotiate a payment plan with your lender. Question 5. Can bankruptcy stop me from being evicted? Yes, but the time period may be very short. The laws regarding eviction vary from state to state, and the length of time you'll be protected depends on applicable state law and the status of the eviction proceeding when you file your bankruptcy. The bankruptcy court has procedures that allow landlords to get relief from the automatic stay on an expedited basis. So unless you have other reasons to file bankruptcy, filing bankruptcy just to stop an eviction is probably not a good idea. Our final question: can I keep my tax refund? It depends. Historically, more Chapter 7 bankruptcy cases are filed in March than any other month. It's become apparent that people who are expecting a large refund file their taxes and wait until they receive their refund. Often the refund is used to pay the attorney's fees to file the bankruptcy. However, under certain circumstances, if the anticipated refund is listed as an exempt asset, you'll be able to keep it once it's received. You should talk to a local bankruptcy attorney to see how much you can exempt. If you can't exempt it, you'll likely have to turn over a portion that's attributable to the period prior to your bankruptcy filing. However, if you receive it prior to filing your bankruptcy and spend it before you file, there's no issue. If you live in California and you'd like to schedule a free half-hour consultation with me, you can call me at 760-409-7705 or email me at martha@bankruptcysage.com. I'll put that contact information in the description below. And remember, this video is for educational purposes only and doesn't constitute legal advice. Every situation is unique, so please consult with a qualified bankruptcy attorney in your area for advice specific to your circumstances. Thanks for watching. If this video helped clarify what bankruptcy can and cannot do, please give it a thumbs up and subscribe to my channel for more bankruptcy basics. I'll see you in the next video.